General's report dated July the 28th, which summarized its investigation into the controversial parole of Vincent Lamar Martin, who was convicted in 1979 murder of the Richmond police officer Michael Connors. As you know, Leader Gilbert, Senator Obenshain, and myself have been requesting this report since we first learned of its existence last week. All three of us have sent letters to the Inspector General on July the 30th and again yesterday. Throughout the parole process, we heard many concerns and complaints from both prosecutors and family members of Patrolman Connors that the Virginia Parole Board was not following the law or its own established policies. Specifically, the release of Mr. Martin was being fast-tracked, and testimony from the family, the prosecutors, and the public were being completely ignored. The Office of the State Inspector General found that all of these allegations and complaints were true and accurate. Most disturbing, his office report found this to be a pattern of behavior from both the current and former chairwomen of the Virginia Parole Board. First, we would like to go through the report and summarize its rather egregious behavior. For that purpose, I'd like to introduce my friend and colleague, the House Republican leader, Todd Gilbert. Todd, thank you.
Sorry, I was muted there. For those of you who don't know me or my background, I was a criminal prosecutor for about 14 years. I've been a criminal defense attorney for about the past 8 years. I have served on the Crime Commission, State Crime Commission. I have served on the Courts of Justice Committee. I was chairman of the Criminal Law Subcommittee. So this area of the law is something with which I'm well familiar, and it shocks me to my core, even more so than just what I know about this, but from not just from a moral standpoint and an ethical standpoint, but now from a legal standpoint. Just the degree to which the law was violated here is shocking to the core. So I'd just like to go through some of the things that are shocking about this report. I think the most notable thing is the degree to which the chairwoman of the parole board went out of her way to facilitate parole for this individual accused of murdering a police officer. She seemed hell-bent on letting him out of prison, for lack of a better term. I mean, she was, it's clear from the report that her goal was to release this defendant and not to do her job in providing a fair assessment of whether he should be released, but rather gathering information that only supported his release, ignoring most fundamentally and most notably the victim's family. And I think she even misunderstood or just disregarded the definition of victim in the Code of Virginia. I think at one point the Inspector General noted that the chairwoman basically said the victim is deceased, so we don't need to worry about victim contact. I think anybody who looks at the code, who understands this area of law, the definition of victim is, and I think this is articulated in the report, family members, people who are affected when their loved one is murdered are considered victims as well. And this parole board, at the instruction of this chairwoman, went out of its way not to contact these victims and hear from them. They went out of their way to actively ignore their request for a meeting. They scheduled a meeting and she did not show up for the meeting. And then turned down other opportunities to hear from other individuals that the law contemplates she should hear from and that the board should hear from, including, I believe, a former co-defendant of this defendant who wanted to share information relevant to his release and not in a positive light. I believe she also did, and this board also did, go out of their way to receive information from other inmates that did support his release, which is troubling that they, again, picked and chose which information they wanted to hear based on whether it supported their narrative and their apparent desire to release him from prison. You know, the policy of the board is clear. The law is clear. This board had to notify people in a timely fashion. They had to notify the Commonwealth attorney and failed to do so. They had to disseminate this information to the family to get input. They failed to do so. At every turn, it appears that they turned down opportunities to hear negative information and only chose to hear positive information that appeared to support a decision that had already effectively been made, especially by the chairwoman. And it really does beg the question what her motivation was. If she has some, you know, I know she went out of her way and kind of went all over the map when this was first brought to light, you know, blaming police for objecting, saying he was innocent on the one hand and he was really rehabilitated on the other. Is really odd the way she went out of her way to support this decision and justify it. And it really begs the question, you know, if there's something else going on here that we haven't yet identified that relates to a potential bias. And I raise that only because it's so alarming and so odd how out of her way she went to facilitate this release of this violent police killer. And I think shedding light on this report that has been very difficult to get our hands on should go a long way toward restoring public trust that this process does work to keep them and their families safe. But that remains to be seen. I think some actions need to be taken before that trust can be restored. So with that, I'd like to turn it over to Senator Mark Obenshain, who's going to have some more comments.
Thank you, Todd. Thank you, Tommy. You know, this administration, its parole board, have really pretty clearly pursued a political agenda that has made Virginia and Virginians less safe. And this report demonstrates the efforts that they made to keep anybody from knowing about it either before the fact or after the fact. I'm the immediate past chair of the Senate Courts of Justice Committee and the immediate past chair of the Virginia State Crime Commission. A couple of observations about the report. First, the finding that the chair instructed no victim notifications to take place in murder cases is deeply disturbing. It seems to be premised upon her instruction that where the victim is deceased, as in a murder, there is no victim. And it's an absurd, not even a credible interpretation of the law, and would seem to evidence a deliberate disregard for the law, as well as the duties for the Virginia Parole Board. It's clear disregard for the statutory definition of victims found in the Code of Virginia. And I would point out that the former chair of the Virginia Parole Board addressed at great length in this report is now judge. And I would have to say that had the General Assembly of Virginia been advised of her conduct on the parole board, I'd seriously doubt that she would have been elected to the bench. According to the report, the former chair, rather incredibly, did not cause notes or minutes of the board meetings to be taken from a period extending from October or November of 2019 all the way through March of 2020. And the parole board meets monthly. And if you look at the parole board website, I would point out that the actions of the parole board and the notations on the website render those contentions not even remotely credible. The Code of Virginia requires the Virginia Parole Board to give reasons for each parole denial. And those reasons are listed in considerable detail on the parole board website for each monthly meeting. Had there been no notes, it would have been impossible to have provided such listings for the hundreds of inmates that were addressed. As you can see from the version of the document that we were provided, there was new language that was added to it at the top and at the bottom in red, seeking to keep this report secret. The text was obviously not in the copy that was provided to the Secretary of Public Safety, Secretary Moran. And when the Office of the State Inspector General did release the redacted version of the report, the one that was predominantly blacked out on July 30, the governor's office referred all questions to the parole board, making it clear that the agency and the people being investigated already had complete copies of the report. And that's further evidenced by the published statement of the Virginia Parole Board that dismissed the findings contained in that then secret report as erroneously. And if you look at that statement, the final clause effectively says, and furthermore, we do not care. It has no impact upon the decisions that we've made. And I would say that that kind of disdain for the independent investigation by the Office of the State Inspector General is unacceptable. Any reasonable person would wonder how on earth the public release of this report might imperil the investigation when the persons and the agencies that are being investigated appear to have been among the first to have been provided with a complete and unredacted version of the report by the Secretary or by the Office of the State Inspector General. Now, a word or two about what needs to happen. The disregard shown by the Virginia Parole Board for victims, for families, for the safety of our communities in Virginia is shocking. It's disgusting, and it must not be allowed to continue. Both the previous and the former chair of the board have demonstrated a significant commitment to a political agenda and a bias in favor of inmates and against victims and their families. Their willingness to violate and ignore laws, policies, and procedures in a manner that ignores the interests of victims and their families has made Virginia and Virginians less safe. Both chairs appear to have violated board policy by willfully excluding the interviews and meetings with victims and other interested parties who opposed the release of the inmate addressed by this report. In one finding, the Office of the State Inspector General found that resistance to contacting victims was stated to be expressly based on the chair's expectation that those witnesses, those victims, and those family members would oppose the release of that inmate. And that was the reason given, apparently, for not contacting those victims. The Office of the State Inspector General found that the board repeatedly violated its own procedures in the case addressed in the report. And worse, the situation does not appear to be exceptional. Over a 30-day period, this particular parole board released over 95 violent felons, including 35 convicted murderers. There have been many news reports from across Virginia about the same erroneous practices being employed in many of those other cases. We call for the resignation of all of the current members of the Virginia Parole Board. And should these members fail to resign, we call on the governor to fire them, following the precedent established by Governor Mark Warner in 2002. The former chair was handsomely compensated to ensure that the laws, policies, and procedures were followed. Obviously, that has not been happening, and indications are that it may still not be happening. While many of the acts and omissions occurred under the leadership of the former chair, it is apparent that the current chair views those as mere technicalities. They are not. Following the 2001 gubernatorial election, outgoing Governor Jim Gilmore expressed his extreme dissatisfaction with the parole board's decision to release 2 killers in Northern Virginia. Incoming Governor Mark Warner said he shared that concern, and he fired the entire parole board and replaced them. We call for Governor Northam to further rescind the parole of Vincent Martin, immediately return him to prison, a new parole board, one that acts in accordance with the law of Virginia. The policies and procedures established by the parole board should be the ones who consider his application for parole, and they should do it de novo. Thank you. I guess
Thank you,
at this
Senator.
point, go ahead, Karen.
I apologize. I had muted myself in listening to you. We have about 10 minutes for questions from members of the press. If you would, either if you're communicating with me right now by text or you are on the chat here on Zoom, please raise your hand. Just give us the high sign and we will get you into the queue to ask a question. I believe Alex Thorson has her hand up to ask a question. I will unmute you now.
Great. Hello. Thanks for answering our questions. I'm wondering first, will we be getting a copy of the report you guys have?
I think you should already have it.
Yeah.
Do.
Yeah, you should. If you did not get one, forward your email to Garen immediately and we'll send one over.
Great. Thank you. And then my next question, you said both chairs. Are you accusing the current chair of something as well? And I'm wondering if you can clarify that, the new chair that took over.
Yes, and Alex, you were at a bit of a disadvantage not having had a copy of the report, and I apologize for that.
That's okay.
The report, and you'll have to look at the report, it details actions by the former chair, and it talks about the transition that was made, discussions and decisions that were made by the incoming chair as well that are in conflict with state law and or policies and procedures of the parole board, particularly with respect to who would be allowed to provide input to the parole board with respect to its decisions. Moreover, the reaction to the release and to the contents of this report were reactions that were provided by the current chair and other members of this parole board, which raised significant concerns about their compliance going forward.
Okay, thank you. I'm sure once I take a look at it, it'll answer some of my questions too. Appreciate it.
All right, up next, I have Bob Lewis, followed by John Burkett.
Hi, everybody. Tommy or Todd, either or both of you can field this one. Legislatively, what do you anticipate might be done to address this cloak of secrecy that the parole board invokes often? Suderline has already got a bill introduced for the special that would subject the votes of the members of the parole board to public disclosure and make it subject to FOIA. Is that something you would go along with, or does it not go far enough? If I could hear your thoughts on that, and start maybe with Tommy.
Bob, very nice to see you again, even if it's through Zoom. You look particularly handsome on the screen there. They muted you. First of all, I think it's very simple. Start by following the existing provisions in the Code of Virginia. That's a very sophomoric and fundamental place to start. Secondly, Bob, I think that while Senator Suderline and others have introduced legislation that would remove the FOIA exemption from the parole board, I think those two initiatives are an incredibly good start to allowing the public to have some insight and some input at what is supposed to be done. I think what really surprises me a little bit, and you know that I've been around long enough when Governor Warner was governor, and just the fact that when he came into office that he recognized what had previously taken place was egregious and, not the term du jour, transparent to the general public, and he immediately acted on that. So I'm hopeful that either the parole board will gracefully resign, recognizing that they're very handsomely compensated. If they do not, I am hoping that this governor will show some uncharacteristic leadership and see that they do resign and a new board is appointed.
Bob, I'll just add to that. You know, I'm not sure, based on where our Democratic colleagues are headed in terms of public policy, that they are going to have an appetite for more transparency in the area of parole, because we are seeing a growing momentum on their side to actually put the parole system back into place for everybody, for every new defendant, not just for the ones that were caught in that gap that they filled from 95 to 2002, or whatever, people that were between that didn't know where they stood. There's a real appetite on the Democrat side to reinstate the parole process, to have people serving 25% of their sentences again, to have people getting extra credit for their time. I mean, you go through the list of things they have out there right now, and we shall see where they land. But whether they want more transparency in the area of letting people out of prison, I doubt that very seriously. I think, however, this episode shows precisely why, in an area like public safety, more transparency is absolutely necessary. And so I'm sure we would support many initiatives that would restore or ensure transparency where it involves, you know, where it involves life and death and the potential for more by these individuals. So that's it.
If I might follow up.
Hang on one second. Even though you expressly excluded me from that, I take no offense, but I would point out a couple of quick things. Number one, transparency, I think you and I would agree, is something that has to be applied even when it's not convenient. And that's something that has been very much missing in this episode. Number two, one of the things that during the course of this rather lengthy saga that we've seen is, if you log on to the parole board website, you will see that each month it releases the list of decisions that it makes. It is statutorily required to list the reasons parole is denied for any inmate, but there is no requirement that it provide to members of the public, to victims, families, or communities across Virginia, either the sentence for which they are being paroled, the crimes that they committed, or the reason that they're being granted parole. And I would respectfully submit that those are some things that need to be addressed and likely will be floated, and I take Todd's admonitions and cautions to heart as well.
Bob, I can see you want to ask another question, but in case some of you all do not have the letter, I would direct your attention to the very last paragraph on the first page, because it's really one of the contributing factors that makes this so egregious. And this guy was convicted and given 30 years for an armed robbery, 20 years on a robbery and 10 years for a sawed-off shotgun in 1972. After 6 years of that 30-year sentence, he was released. And less than 100 days after he was released on that 30-year sentence, he murdered the police officer. This is just outrageous. And I just say that in case some of you don't have the letter right in front of you. Excuse me for interrupting you, Bob.
And Bob, I'm going to interrupt you too. And I got to catch myself every once in a while, because I realize that I work and live and deal with this policy area every day. Not everybody fully understands. Parole was done away with in 1995 in Virginia. these individuals that we're talking about are still parole eligible, which is why we still have a parole board. People who go to prison today are not eligible for parole. They have to serve 85% of their sentences if they are of good behavior. So we did away with that. It's called truth in sentencing, that when a jury is sentencing someone, that the amount of years that they give them, they can be assured that that is the punishment that they are handing out is what is going to be served. So there's sort of a dual system going on right now. And these people that are being granted parole belong to that older system. There is, and to confuse matters further, we do still have geriatric parole. So if you're of some age or infirmity, you can be eligible for parole as well. But the takeaway is that we did away with parole a long time ago, and these are vestiges of that older system that are now still being abused, and a good reason why we should not return to that system, because it's obviously remains very broken. So Bob, I'll let you go ahead. I'm sorry.
Mark, actually, I was going to go to you with a follow-up, but you answered my question somewhat without me asking it. What you just came up with and what you told me, is that something you anticipate might be drafted into legislation in the next 2 weeks and perhaps offered during the upcoming special?
Yes.
Okay. I yield back the balance of my time.
Thanks, Bob. It's always good to hear from you. Next up is the long-suffering John Burkett. John, you are up.
You guys hear me? Everybody hear me? Okay. Thanks for taking my question.
Yes, sir.
I spoke with Senator Obenshain a couple of days ago, and it's still, this report raises questions. The inspector, the OSIG, is a separate entity. No one should be looking at this report until the findings are made public. Do any of you see that this report may have been sent for proofreading or scrubbing before even you guys got to see this?
Well, I don't know, John. I do have just a few questions, and I think that is, frankly, a very good question that you should be asking. We can't answer that. Somebody else is going to have to answer it. I know that I was in communication with a number of people who are on this Zoom call today on the 24th of July, a Friday, and was told by members of the media that an OSIG report was imminent, and was told by a person or two on this Zoom call that their sources said that it was either in the governor's office or in the office of the attorney general. It does raise some questions. The 24th is 4 days before the date that is at the top of this report, July 28th. If it was in the hands of the attorney general or in the hands of the governor, I would like to think that some of the participants in this call are going to be asking questions about why, and about whether there were requests that any changes be made, when they got it, how long they had it, and why on earth were they provided with advanced copies of this? And moreover, when did the parole board get it? And did they provide input beyond their participation in the investigation and answering questions? So, John, I can't answer that. The only information I have was passed along in the form of inquiries from some of you about whether we'd seen it on the 24th, because your sources were telling you that it was somewhere in the executive branch, not in the office of the state inspector general at that time.
Mark, this is Tommy, if I could tag team on that. It is interesting to me that on the redacted copy, that was unsatisfactory. I don't recall that there was anything stamped on it saying this is a draft, this is undergoing revisions, do not share it until there's a final version of it. Maybe that's the attorney side of me, but John, I do know that when we draft matters and it's considered a draft, we're circumspect about distributing it, but also we make it abundantly clear that it is a draft and a work in progress. I haven't seen that anywhere. Nobody's suggested it anywhere. And why would they send out a redacted copy that was a draft and a work in progress?
All right, thank you. Next up is AJ from VPM. Thanks for waiting, AJ. You're up.
Definitely. The first question is, I wasn't able to start a recording for this meeting. So is there any way that a copy of this recording or of this Zoom conference can be sent to me once it concludes?
Absolutely. Just as soon as the computer finishes chewing on it and processing it and doing whatever voodoo, I'll make sure that it gets to you.
Perfect. And so for my question is, you guys are obviously, you're meeting today discussing this. What is the big takeaway? What does the community need to know about the steps you guys are taking to address this issue? And what comes after? What comes next once this concludes?
Well, this is Tommy again. I don't mind jumping in. I think first of all, and perhaps paramount, if somebody could put their system on mute because we're getting a bleed over, that would be very nice. First of all, I think the public deserves an awareness and some insight into the process. Otherwise, the statutory provisions that have currently been written by the General Assembly that are in the Code of Virginia would have never been put in there if we wanted to try to masquerade or cloak what was going on. That's very fundamental to me. Secondly, as Mark has pointed out, and also as Todd has pointed out, the definition of victims is very important in this situation. The sole victim is not the decedent. We have family members who are considered victims by definition in Virginia. We have victim impact statements that are allowed to be presented before boards and courts. And I think it's an excellent reminder to those families that have had someone incarcerated as a result of a loved one that's been killed or that a crime has been committed against, that they have rights and that those rights are going to be respected, and that the laws in Virginia relating to the parole board and their internal guidelines and rules are going to be followed. I think that that is a very reasonable expectation that an aggrieved family should be entitled to. Also, I think the awareness that someone like Mr. Martin is being released, that the family ought to be entitled to know that that individual is being released. I can tell you under the federal guidelines that victims are notified before someone is released from incarceration. So I think there are a number of levels to look at this. And as I've said earlier, we're just advocating something very simple. Follow the existing law. If you can't, then we will figure a way to change it.
I'll just add, this individual murdered a police officer in cold blood, and he was convicted of doing that. And this parole board went out of its way to secure what was apparently their intention, which was to facilitate his release. And they broke every rule and procedure and law in the process to facilitate that. And somebody needs to be held accountable. And either the people, either the people who are directly responsible need to take responsibility for themselves and step aside, or the governor of Virginia needs to step up and do his duty to remove people who have clearly broken the law, clearly violated procedure, clearly done more to reopen these wounds of pain for the family of the victim through their action and inaction than one could have thought possible. Just going out of your way to ignore and prevent victim input is shameful at best and blatantly illegal at worst. And we hope to see some fundamental change there as a result of bringing this to the public's attention.
Does that include getting rid of the parole board as it stands now?
Yeah, we're asking for them all to step down and for the governor to fire each and every one of them if they refuse.
Hey, I'm with VPM. I'm not sure if Garen said AJ was VPM. I don't know if you meant for me to ask a question as well.
Well, yes, go right ahead. You're our last question.
Okay. My question is for Delegate Gilbert and Senator Obenshain. You both mentioned that the chairwoman of the Board of Parole has been acting out of bias. I was hoping you could maybe expand a little bit on where you think this bias might be, and just expand a little bit on what you mean when you say that she's acted out of bias in granting parole to this individual.
I don't know. I know I use the word bias, and I don't know if there is a bias, but I raise it because everything about this process stinks so much that it reveals a potential for there being a bias. Why did she go so much out of her way to facilitate what is clearly her intention? I think there's some reference in the report about her working on this for 4 years. Clearly, she has an interest in facilitating Mr. Martin's release that goes beyond her role as chairwoman of the board. This former chairwoman is a judge now, as Senator Obenshain mentioned, and that is a position of public trust. That is a position of, where you're dealing with matters of criminal justice. And so, again, it's very concerning that despite all of what we know now that she has elevated to that position, there's not anything anybody can do about that at the moment. But I think the potential for bias exists, and there's something, I've been at this too long to not smell a rat. I feel like that there's something more that we don't know about her interest in this particular case, and I would love to know that, and maybe somebody could ask her.
Yeah, and when we talk about bias, there are competing interests here. I mean, we have rehabilitation, merit on the part of inmates who are being considered for release on parole, and we weigh that against safety of the community, the rights of victims, and in this instance, the bias in favor of convicted felons and the disregard for the interest of safety of communities and for the interests of victims is, quite frankly, stunning. I mean, the notion that we're not going to talk to somebody who claims that he was a gunshot victim, which I believe the report made reference to by Mr. Martin, that they would not even take a minute to listen to him, that they discounted that potential information, that they sought actively to prevent family members from providing input, that they did not provide notification to the Richmond City Commonwealth's attorney. Who are they to decide that unilaterally that a Commonwealth's attorney might not have some relevant information that goes to the fitness of that inmate for parole, or that goes to the question of whether his release is in the best interest of the safety of the community. That kind of unilateral determination by the parole board and disregard for the statutory scheme, I think pretty clearly shows a bias that is deeply problematic and undermines the interest of public safety and safety of our families and communities across Virginia. And you look at that 30-day period and the 95 violent felons and more than 30 murderers who were released, and you're going to see that disregard taints many of those cases in different areas of Virginia, different demographics. It is something that certainly appears to reflect a pattern. I believe this report really just addresses one case. I hope that there are investigations ongoing with respect to other cases, so we can see the extent to which there is a pattern of bias and disregard.
Well, unfortunately, folks, we're going to have to let that be the last word. I appreciate everybody being on with us today. Senator, Delegate, thank you so much for taking the time to be with us. Members of the media, if you have additional questions, feel free to reach out to myself or Jeff Ryer. We have the documentation if you did not get it. We will make this video available to anyone who wants it. And again, if you have questions, please don't hesitate to reach out. And with that, thank you all for being here. This concludes today's press event.